The case Meinhard versus Salmon raises some interesting questions to think about. UCLA corporate law professor Stephen Bainbridge compared this rhetoric to the story of the Good Samaritan. The story or parable of the Good Samaritan is found in the New Testament, in the Christian Bible, specifically in Luke 10:25 to 37. In this parable, there is a lawyer talking to Jesus. The lawyer asks Jesus, "How do I gain eternal life?" Jesus replies, "The way to eternal life is to love the Lord your God with all your heart and all your soul and all your strength and all your mind, and love your neighbor as yourself." Love your neighbor as yourself. The story continues and talks about several ostensibly good men who see an injured person by the side of the road and walk by, until a Samaritan takes pity on the injured person, picks him up, takes him home, bandages him, and takes care of him. The clear implication of the biblical parable is this is how to love your neighbor as yourself. Cardozo's rhetoric of punctilio and honor the most sensitive, Bainbridge argues, implies that Cardozo expects the same self-effacing, self-neglect for the sake of another in the case of partnerships. In Latin, this is called agape, this self-effacing love for another. Bainbridge called his article, "Must Salmon Love Meinhard?" Is that really what Cardozo implies? Should that really be the law? When one person enters into a limited joint venture with another, does the obligation for each of them to put the other's needs above their own really form as a legal matter? Is agape what the law requires? There's a different Latin word for love, filio. Filio is Latin for the kind of love you have for a friend. Filio is a more selfish kind of love. Filio is like, I love you because I enjoy spending time with you. Whereas agape is a sort of love like, I would do anything for you, even at the extinguishing of my own self. Agape is selfless. Agape is the willingness to let one's own self be destroyed, rather than let the other cease to be. Cardozo seems to be saying something almost at that extreme level of loyalty as between partners, or at least between the managing partner and the investing partner in that case. Cardozo seems to be suggesting that the managing partner has this obligation to completely bury his own interests for the sake of the partnership or joint venture. I'm not really sure that Cardozo meant this high standard of agape should be the law. In fact, I am certain that agape is not required by law. Why then do we read and discuss this case in law school? This case sets a tone. It identifies a tension in business law that runs throughout all of business law. The case is a story about the highest aspirations of business law. Aspirations, but not requirements. Business law is full of aspirations. Today, there is a lot of focus on environmental and social governance, which is the notion that corporations should look out for people and the planet in addition to making profits. Some people would even have corporations forego profits for the sake of employees, customers, and other such stakeholders in the corporation. Even though Meinhard versus Salmon is about a joint venture, which is not even a formal business organization, and even though Cardozo articulates an aspirational goal, not the legal standard, I continue to use this case to kick off my course on business associations. And I do this deliberately in order to remind students that much of what we encounter in business law is the tension between what we would like people to do and what we should legally require them to do. In his opinion, Cardozo was not really speaking about the law. The law only requires some minimum standards of conduct to avoid legal liability. Cardozo was saying that there is more to business law than meeting a minimum standard. You can't be jailed for driving past an injured person. If you go past a car wreck, the law does not demand that you stop on the highway and give aid. You do not have to have agape for the stranger to avoid legal penalties, but it is a worthy aspiration to do so. And so this case is not here to teach you what the law is today. This case is here to give you some sensitivity about what business law is trying to encourage. Catholic theologian Daniel David McCluskey said, "This age is mere iron and aluminum and plastic. We don't live in an era of pagan gold or Christian silver, but an age of mere iron." Again, the message here is our world, our law is realistic. It demands only what can reasonably be done, but business law can have and does have higher aspirations. Maybe Dr. Martin Luther King said it even better. The law cannot make people love their neighbors, but it can stop them from lynching them. And that's what business law does. It's not here to make partners love each other with agape. It's not meant to have people ruin themselves for the sake of a partnership. Business law requires only a minimum standard so that basic expectations are met and so that businesses function properly. Salmon does not have to love Meinhard. Such a lofty standard would be too indefinite. What does it even mean to have that amount of dedication to a business partner? It's just too lofty and vague to be demanded. But it does have a value, and that's what we are striving towards. We are striving towards this notion that partners in a business should put the needs of the business first, and not themselves. Again, should, not must. Partners should put the needs of the business first, but as we will learn, what they must do, lest they face legal liability, is something less than self-effacing love. What we see in the case of Meinhard versus Salmon is a story about aspiration, about what Cardozo wishes for business society, but not necessarily what he would require. He doesn't even require filio, brotherly love. He doesn't even require that partners necessarily like each other. And neither does business law. If you want to confirm this, look at the Model Business Corporations Act, Section 8.30, and compare it to Section 8.31. You will see there are standards of conduct that are different from standards of liability. In the MCBA, the Model Business Corporations Act, we have one bar for what we want people to do, and a lower bar for what people can get sued for not doing. Law is not a substitute for morality. Law does not replace social trust. For this reason, one should still be careful in choosing business partners. Although the law enforces a lower standard, as ethical lawyers, we can and should always encourage our clients to do more. I think that's the biggest takeaway from Cardozo's opinion in this case.